Hello, and welcome to Law Deals, the podcast for legal professionals navigating the business of law, law firm partnerships, and law firm ownership transitions. I'm Ed Alexander, and today we're diving into a topic that every law firm owner deals with, but that few truly understand: the nuances of professional liability insurance. This is so important, especially when it comes to the situation of partnerships, succession planning, and selling and buying practices. I'm joined by Peggy Hewitt, Resources and Services Manager at Florida Lawyers Mutual Insurance Company. Peggy brings a unique perspective to our conversation because she's not just an insurance professional, but she's someone who's walked in our shoes. She was a partner in a general liability and workers' compensation defense firm for 22 years. Before that, was in-house with Walt Disney for over 7 years. She's actually had 120 jury trials under her belt, which is pretty amazing. Both as an assistant state attorney and then also as assistant general counsel. So she really understands the real world risks that lawyers face. She's also created and moderated more than 100 CLE presentations for Florida Lawyers Mutual Insurance Company, which we'll just call FLMIC, on everything from malpractice prevention to trial advocacy. So welcome to Law Deals, Peggy.
Thank you for inviting me, Ed. It's a real pleasure to be here. I think I owe you one because you have, helped us put together some pretty fantastic risk management CLE webinars in the past, and I'm trying to get you to do another one.
Thanks so much. Appreciate it. All right. Well, let's dive into this, right? So let's start with the basics about professional liability insurance that really many lawyers I talk to get wrong. So when a law firm owner is thinking about the coverage amount for professional liability insurance, what should she consider?
Okay. First of all, I do want to do a couple of disclaimers. One, I am not an insurance underwriter. I'm not a certified or licensed underwriter in the state of Florida. Therefore, there are some restrictions on things that you can and cannot take away from our conversation here today. Because I'm not an underwriter, I will not be giving anyone any specific information or advice regarding specific insurance coverage. What I can do as an attorney, as a lawyer, and as a risk manager, I can give some general informational advice that I give as part of my job as services and resources manager at Florida Lawyers Mutual, and as a curator of risk management materials. So taking those disclaimers.
Well, I'm going to interrupt you there, but let me Sure. Just say that all of this podcast is always just informational, right? Information and entertainment. And so at the end of the day, nobody should walk away from this or any other episode thinking that they've received legal or other professional advice. So with that, go ahead and take it away.
Perfect. Insurance coverage is very specific to the individual lawyer, your individual practice area, your risk management past, your claims history, even the area of the state of Florida where you perform the majority of your practice. So taking that into consideration, that has a little bit more to do with premium rather than coverage. So as an attorney who is first seeking coverage for their practice, they want to take a couple of things into consideration. One is the fact that if you're a new lawyer, you have very little risk history because you haven't been practicing very long. Think of professional liability insurance coverage as cumulative. The longer you've been practicing, the longer history you have of attorney advice given, attorney contracts created, business dealings concluded, monies exchanged hands, people incarcerated or not incarcerated. So
cases resolved, all of those things. Yeah.
Yes, it's cumulative. So the longer you've been practicing, it's highly likely the higher your premiums are going to be, especially if you have claims made coverage. And we're going to be talking about the difference between occurrence and claims made coverage during this program. But when you're an attorney seeking coverage and what kind of coverage you need, you're the second step after understanding what kind of a practice that you have and what risks there are pertaining to your particular practice. For example, the vast majority of attorneys in the state of Florida will go their entire career without receiving a complaint for malpractice. They just will. Right now, there are 110,000 members of the Florida Bar. There are 90,000 active practitioners in the state of Florida. And I do believe that 70% of those attorneys are in need of professional liability coverage. There are certain practices that do not require coverage. For example, government attorneys do not require coverage. Attorneys who do pro bono work are generally covered by the company that is sponsoring their pro bono work, or the pro bono firm that they are doing their work through, such as Legal Aid, Florida Rural Legal Services, and other volunteer agencies. The rest of us need professional liability insurance to cover everything from, for example, a false claim that you have committed some sort of professional liability or professional misconduct, and there's a complaint to the Florida Bar. And I state this because out of the 90,000 attorneys that are practicing, about 10,000 of you will receive a nasty little letter from the Florida Bar or your local bar office investigator that you have had a complaint filed against you. And I mention this because that's generally the first incident that occurs that makes you glad you have professional liability coverage or wish you did. Because professional liability insurance, depending on what you purchase, can cover the losses that you incur as the result of a complaint to the Florida Bar. For example, if you need counsel, your professional liability insurance will pay for your counsel, even when it's just a complaint to the Florida Bar. And
let me stop you there. Let me stop you there, right? So I think what I'm hearing is, look, you got to have the coverage, even if the likelihood of you receiving a malpractice claim is low, that it's a much higher likelihood that you'll get a bar complaint at some point in your career.
That's true.
When you look at those percentages, right? And that if you purchase the correct coverage, it will assist you through that bar complaint as well, right?
It will.
So the premium is going to be dependent on practice area. It's going to be dependent on where you practice. Obviously, certain areas have higher claims rates than others, and so that factors into it as well, the risk factor. But if I'm a solo practitioner and let's just say I'm doing family law, so I'm doing your garden variety divorce. So now I'm looking for professional liability insurance. What should I be looking at? Is it a $500,000 policy? Is it $1 million policy? Do I want a $10,000 deductible or a $5,000 deductible? How does that all work? What ends up being the numbers that make the most sense?
Okay. When it comes to coverage, it's really a determination by your professional underwriter who is trained in all areas of practice. It's basically auditing your practice. What are the risks to your practice? What is the history of this particular area of practice? What risks for, what are the damages that can come about as a result of a successful malpractice claim against you and your firm? So those are all things that have to be considered when you're trying to decide how much insurance you want or you need. And I cannot answer those questions. That is really and truly a mathematical equation that is created by your professional underwriter who's trained to take into consideration all of the risk factors when it comes to your particular practice. I don't know that any two lawyers have exactly the same coverage or the same premiums when they're sole practitioners, just as I don't believe that there are any two particular law firms, whether they're small or large, have exactly the same coverage. Coverage is actually tailored to you and your practice, and there are a lot of good reasons for that. For example, if you're a family law attorney, you're not looking at hundreds of millions of dollars in actual damages as you might be in a commercial transaction or a professional or a personal injury type of situation. You're not looking at the same size of damages or the awards. I can say that there are certain factors in the state of Florida, signage, that has increased the expectation of some clients and litigants as to what damages can be. However, that's not a real indicator of what your real risk is. So the folks that are really and truly going to be able to answer that question the best is your professional underwriter who takes all of your particular information into account, your practice area. How much of a percentage of that practice area do you stay in? Do you ever wander out of your practice area?
Yeah.
Are you board certified? I mean, there are a lot of factors that go into this. And for me to be able to say,
you should get
you
$1
should
million
have
or
$5 million
$500,000
in
or whatever.
coverage.
Yeah.
If you're a family attorney, it's unlikely that that type of damage is really looming on your particular practice horizon. But
Yeah. So
again, that is
ultimately it's a self-evaluation, right? It's looking at what's the size case you handle, because if your family law practice is focused on tech entrepreneurs that have billions of dollars of assets, it's going to be a little bit different than, focusing on a middle class divorce with maybe an executive or something along those lines. So yeah,
Yes.
Perfect. Okay. So now you mentioned something before about a claims made policy. I think it's important to discuss what a claims made policy is and how it works.
And that is really important because claims made versus occurrence is a legal concept, an insurance concept that people struggle with. For example, I was more than 2/3 of my career has been in the area of product liability defense, premises personal injury defense. I have always represented manufacturers of products that kill and maim people. I mean, that's how I've explained my practice. And so there were occasions where I would have nightmares about the size of the awards that could occur as a result of my practice. If I made a mistake, or if there was a mistake that I made, for example, at the beginning of a case, versus at the end of maybe a case that extended for a 4 to 5 year period, which is, I know that the courts are trying to stop cases from lasting that long, but I've had cases that lasted as long as 10 years. So would I still be covered for something that I did 10 years ago? And that's what we're talking about, the difference between occurrence coverage versus claims made coverage. Occurrence coverage is basically you seek redress through the insurance company that had your coverage at the time the malpractice event took place. For example, you wrote a will 10 years ago and the law changed. You did not make a change to the detriment of your client, but the client is only 30 years old when you wrote that will and they don't die for another 70 years. What insurance policy will cover this malpractice? Well, it can be confusing. The great thing about claims made coverage is it's real simple. You go back to the date, the retroactive date of your actual coverage with the insurance company that you have now.
So let's back that up real quick. So what we have is that you look at the retroactive date as the first date when this policy covers, which may be before you actually purchase the policy, right? Because you want to get coverage for acts that occurred previously, right? Maybe you were insured under company A and you moved to Flemic, and now Flemic is taking over that risk during the time that you were covered by company A, right?
Yes.
And so in a claims made policy, you've got to have the work has to be done during the coverage period, and the claim has to be made during the coverage period, right? So that's why we have a retroactive date that can be often many, many years prior to the time that we have purchased our first policy from this company, right?
Yes.
Okay. So it's got to be both of those in there. And so now, right, we've got this extended period. And so what that does is that implicates then transitions. So we go from a transition where we're bringing somebody into the firm, right? And so the question then becomes, when are we covering that person for? Well, so if I have a policy that begins January 1, 2020, and I hire a lateral into my firm on July 1st, 2021, right? So what
Yes.
is that lateral coming in being covered for?
Okay. Well, as long as there is uninterrupted coverage, you can negotiate your retroactive date to as far back as you would like coverage. In this particular situation, it depends on whether or not your prior firm is going to continue your coverage for their protection as well as yours. For example, you move from a large firm to a smaller firm, and even vice versa. When you change your firm, you can technically be covered by your prior firm. And generally that's what occurs because they want protection for your past events, your past actions as an
Assuming
attorney.
that
So they would be covered.
right, and that's assuming that they continue, right?
It's
Because
assuming they continue.
because if the firm breaks up, even after you've left, you now have a big hole in coverage.
Yes, you do. I don't want to get ahead of myself. Basically,
No, it's okay.
When you move to the new firm and your new firm, either if you're a sole practitioner or a part of a firm, basically your entire history is provided to the new insurer or the insurance that covers your new firm or your new position, or if you are obtaining new insurance. And you're depending upon your activities in the past or what your risk level has been, and whether or not, of course, your prior firm is continuing that coverage for them and then you as well. That's going to determine what your new coverage will be. I can talk about risk, and I can talk about your personal risk tolerance, but generally what underwriting does in any professional liability insurance company is seek to cover any and all past events that really is a risk to you because of your practice. It depends on what your practice is and what your practice history has been. That will make a determination as to how far back you want coverage. And there are a lot of things that have to do with statutes of limitations. I mean, for example, if you're not doing wills and estates on trust work, you're a transactional attorney. Once a case is generally closed, it depends on whether, when the malpractice is discovered, and then the statute begins to run. What I'm trying to say is there are a lot of different factors that go into how far back you want your coverage to go. And again, depending upon your risk tolerances, and what you can negotiate with your insurance company. Do you want all of your history to be covered? That's a possibility. Again, that has to do with your particular practice, the statute of limitations on when a claim for malpractice can be brought. So there are a lot of different things that you want to think about.
Yeah. So what I've seen happen is a partner leaves firm A and goes to firm B, and in that process, firm A will either disintegrate or everybody else is retiring, which is true. I've seen that, and then they liquidate the firm. The partner who now has moved over to firm B has no coverage for that work that they did at firm A, and so they really should have purchased a tail policy for the work that they did at firm A, and they're often shocked to learn that they have no coverage for that prior period. And then they come to firm B and they realize it at some point and want firm B to cover them through that retroactive date of firm A. And that's a pretty significant ask because the premium can be huge the premium increase can be huge for that coverage. And so going from one firm to another as a lateral is very important to negotiate this component of does firm B that's bringing you on now give you a bonus to pay the tail policy so you're insured that if firm A goes out of business or something happens where they're no longer maintaining that policy in the same manner, that you are covered as a partner coming into that firm. right? And so
Yes.
the flip side of that is now firm A. Let's say it doesn't go out of business in my example here. So partner who leaves was a partner who practiced in a very high risk area, wills, trusts, and estates. And so they are the partner for wills, trusts, and estates. And when they leave, they take the wills, trust, and estates department with them to firm B. So now firm A is sitting there and they've had wills, trusts, and estates as in their practice area for 5 years, and they are expecting their premium to go down. What really
Certainly.
happens, Peggy?
What really happens is you walk away from that risk. If you are not, if you're taking the high risk practice with you, that risk goes with you. If you are not taking that high risk practice with you, then you leave that risk behind. The great thing about professional liability coverage is you are not responsible for the sins of your partners. You cannot be, okay, I'm not going to say can't be. Anybody can sue for anything. But when I talk about a successful suit for malpractice, I personally have not seen where an attorney has been required to insure themselves for the malpractice events of another attorney, even if it is a partner, because you're not taking the risk of the entire firm any more than you continue to carry the risk of any associates that were members of your past firm. That risk you leave behind, but you do take with you yours.
Yeah. So now if firm A is expecting their premium to go down because the wills, trust, and estate partner left,
yes,
what's in store for them?
They renegotiate their insurance coverage with Florida Lawyers Mutual Insurance Company. When that's a substantial change in circumstances, and that's an insurance coverage risk management event. And this is something that you want to be in contact with your professional underwriter pretty much with any change that occurs in your practice, whether it's taking on new attorneys, if you're growing your firm, you want to know that your coverage is going to grow with your firm. The same thing happens when you reduce the size of your firm or the firm splits up, that you notify your insurance professional that you are no longer practicing in this particular area and that you expect that your future premiums will go down. What I'm trying to say is that these are events that you need to pay attention to. For example, there are other substantive events during the course of your practice. For example, you decided to substantively change your practice area. A lot of that occurred during COVID. There were a lot of changes to the insurance industry when no one was traveling by car, airplane, or going to restaurants. A lot of practices changed, and a lot of attorneys went out into various and sundry different areas of the law. For example, the risky area of wills and trusts. A lot of attorneys who were suddenly underemployed because of COVID and the changes in the economic environment for a pretty substantial period of time did venture into a burgeoning area of the law as a result of people wanting to resolve their estates and trust issues in advance of any type of tragedy. So there were a lot of insured attorneys who weren't adequately covered because they didn't bother to notify their insurance carrier that a substantive change had occurred in their actual practice area and their risk had actually increased substantively. So again, this is another area that you want to be in contact with your insurance professional about. When there is a substantive change in your practice, either because of personnel or practice area, you've made a substantive change in your risk. Therefore, there is going to be a change in your coverage, and you may want to increase your coverage to cover you for things that are unanticipated by that change in your practice.
So going back to the example of law firm A and law firm B and partner who moves from law firm A to law firm B. So partner takes the estate, trusts, and probate practice over to law firm B. But law firm A, he worked there for some number of years, and they obviously bill clients and did work for clients. So they have an ongoing risk factor, right? And so on some level, that coverage, because it's claims made, has to be maintained for an extended period of time because of that estate planning component. So are their premiums going to reflect that continuing risk that the company is going to insure for, that the Flemic or whoever their company is?
I'm going to tell you the honest truth. I'm not sure, because it is just so individual. It really depends on a lot of factors that I, as a non-licensed underwriter, I have not taken the training. I have not taken the licensing exam, and I have not ever practiced any type of underwriting or really gotten into it. While I have a grasp of underwriting because of my experience in risk management, I really can't tell you in any unequivocal way, or to any unequivocal extent, what exactly the effects are going to be for that type of change in your practice, as it will be reflected in your premium.
But that's actually perfect, Peggy, because this is the point I'm trying to make, right? Is that at the end of the day, when a lawyer, and this has to go into a partnership agreement, when a lawyer leaves a firm and they go to another firm, they may cause unintended consequences for the departing firm. And so the process of buying that lawyer out of their interest in the firm could actually be them having to cover some of the liabilities that they left behind in the firm. For example, what if there is a claim and the firm has to pay a deductible? Should that come from the departing lawyer? Or should that come from the pockets of the remaining lawyers when that claim came about because of the departing lawyer's work? So these are all things that have to be included in that partnership agreement. And that's why understanding the components of the professional liability piece really plays into all aspects of the practice and the business of law.
That was one of the reasons why I was interested in doing this podcast with you, and then talking you into doing a CLE for just on this actual subject, because it is very subjective. It's something that all lawyers, when they create a partnership agreement with another lawyer, they have to take into consideration. And when an attorney or a partnership is breaking up and a partner is leaving the firm, that also has to be negotiated, because somebody is going to be paying that premium, whether it's nose coverage or tail coverage, whether it's an occurrence, a policy, or a claims made policy. These things have to be negotiated in advance of the partnership dissolution. And it's one of the things that you really have an intrinsic knowledge about and advise clients every day. So I was excited about bringing this topic up because it is so important. There are so many changes in the legal industry now, and I believe that there are going to be some pretty serious changes in partnership agreements and consolidation of law firms over the next 5 years. One, because of technology, and two, because consolidation seems to be the way that some firms are expanding their reach, not just into other practice areas, but also into other states. So this is something that you really need to concern yourself with whenever you as an individual attorney are making any type of agreement when it comes to partnership or dissolution of partnership.
Right. Exactly. I mean, the issues that come up out of ongoing partnerships are really manifest, and you've got to deal with them early on, because the minute you really open your doors, the dynamics change. Before you start, you're equal. At some point in the process, you may also be equal, and it may also be a good time to revisit that partnership agreement. But the bottom line is you got to pull that thing out of a drawer and look at it. I've said this before on the podcast. I've looked at partnership agreements where the buyout amounts were ridiculously low given the amount of business they were doing. And I've been told that, oh, that's been in there since day one, the day we started, Anyway, all right. You mentioned
Well,
two
the great
terms.
thing, I want to just mention the great thing is you can kind of take a look at it every year because professional liability insurance has to be renewed every year. It has to be renewed. You have to give all new information to your underwriter. You have to report if there have been any claims made in the past 12 months. You have to report any changes in personnel. So it is really a great idea, kind of on a yearly basis, kind of like changing the battery
Right.
in your smoke detector on April Fool's Day every year. I mean, make a point of not just addressing your insurance coverage at the renewal period every year, but also thinking about taking the changes in your risk and your insurance policies or your insurance policy premiums into consideration and make that your partnership agreement grow with that cumulative risk that you're continuing to cover.
Yeah. And the changes in circumstance that occur, they can occur slowly. They can occur quickly too, but if they're occurring slowly, you can work those into the agreement every year as you look at that and say, okay, well, let's make an amendment in this area or whatever, that kind of thing. So good. You use two terms. I want you to explain the two terms. One was tail coverage and one was nose coverage.
Okay. Nose coverage is also known as prior acts coverage. And I'm looking at my notes because I want to make sure that I'm getting these two terms correctly. It's kind of a type of insurance protection that covers claims for incidents that occurred before your new policy's effective date, but are reported after it begins. It's an alternative to tail coverage, which is an extended reporting period which is purchased from the previous insurer to cover past incidents after that policy expires. And tail coverage generally comes into play when you retire, when you fully retire from a firm, when you become a judge and leave the practice of law, or when you have a disability that prevents you from continuing the practice of law. So basically, tail coverage just simply, it extends your reporting period, meaning you will cover yourself for a period of 2, 3, 5 years beyond your retirement that will continue to cover you from any claims made for prior events, for prior activities as a lawyer.
So the short of it is you stop producing legal work, but whereas your policy would end at that point in time, what you're giving yourself is the opportunity, because it's a claims made policy and the claim has to be made, the work has to be done and the claim has to be made during the policy period. So what we're saying is we're extending the period when you can report a claim where the work was done during the pre-tail policy period.
Right. Exactly.
Okay. Perfect. And then nose coverage is saying, hey, an example would be, I'm going to switch from company A to company B. Company A covered me from January 1, 2015, and I'm switching now January 1, 2025. I don't want to lose that coverage because the minute I terminate company A, I lose the ability to report to company A. So if any claim comes up over that period, I'm not covered. And now by telling company B, great, I'll go to you, but you got to cover me from January 1, 2015. That's the nose portion. So
yeah, it basically allows a professional or an attorney to switch your insurance carrier and maintain continuous protection.
Right. So you have to have a carrier for that period. We can't just go and say, well, you know what? I wasn't covered for 20 years. Let me go back and cover myself for those 20 years. That doesn't work. So
Nope,
good.
It doesn't.
Okay. So I understand that Flimic offers extended reporting coverage for free in certain circumstances. Can you describe those?
I sure can. It's called an extended reporting factor. If you do this within 30 days from termination of your policy, And this is the scary part. In the circumstances where it is not free, you have to pay the entire premium within 30 days of the extended reporting period. But you're asking about where does Florida Lawyers Mutual provide free, literally at no charge, extended coverage for insureds. And that occurs, for example, you can have 2 years of no premium coverage for disability and retirement, upon disability and retirement, as long as you have had continuous coverage with Florida Lawyers Mutual for period, and let's say available and termination of coverage unless the policy is canceled for non-payment of premium or is non-renewed by the company. And of course, you have to certify that you've had, what your circumstances are. So the extended reporting coverage, if you are disabled or upon retirement, there's no charge for 2 years of coverage. Now, if you leave your firm and you have been continuously covered by Florida Lawyers Mutual Insurance and you become a judge, you get 4 years of extended reporting coverage for no additional premium charge.
Nice. Excellent. So let's kind of talk about succession planning and coverage continuity, right? So,
Yes, sir.
So we kind of talked a little bit about retirement. What mistakes have you seen firms make in this process regarding coverage when they're either doing succession planning or a lawyer is retiring?
Mistakes made are, and of course the main one is not having professional liability coverage beyond your event, before your change event. And the reason why I say that it's a mistake is the same reason why we talked about at the beginning. Your risk is cumulative, and it doesn't leave when you retire from practice, or when you change your practice, or you're disabled from your practice. That simply does not change. Other mistakes that occur are by not understanding that insurance in and of itself is negotiable. If you feel that your risk is getting out of hand because of your practice or a partner or the area that you presently practice in, or you've extended your practice into an area that has a higher, what we call it a risk mod. It's not really that, but their insurance is more expensive in South Florida than it is in the Panhandle. It just is, because the risk is higher. Damages tend to be higher. The firm size tends to be larger. The risk tends to be greater. And lawyers make mistakes in not taking those changes into consideration and not negotiating for the practice or the coverage that will cover their risk tolerance. And when I say that, your risk tolerance is different from everyone. I'm going to compare it to homeowners coverage. If you have a $500,000 house and you live in Central Florida and there's a hurricane coming, you might want to take a look at your coverage to determine whether or not you have replacement value coverage. When you purchase professional liability insurance,
if a hurricane's on its way, it's too late.
It's too late. You're not getting any coverage.
Yeah.
Unless you have a really good relationship with your insurance carrier, with your broker or your agent. And the same thing happens with any other insurance, especially professional liability insurance coverage. The mistakes that are made by attorneys, one, not having professional liability insurance, and then a claim comes and all of a sudden you're paying for your lawyer out of your pocket, and there's no deductible, but there's also no coverage.
Right. So hold on a second there, Peggy, because that's a huge, huge issue, right? It's not about whether you did anything wrong, right?
No.
Because you could be the best lawyer and get a claim against you. It is about having to deal with the defense, right? And so those defense costs are part of the policy coverage if you elect the right policy.
Yes.
Yes, you will have to pay your deductible, but at the end of the day, after your deductible, those coverage costs, the defense costs, will be paid by the insured or insurer.
By the insurer.
Right?
Yes.
Yeah. And so those costs are, and it's very typical, right? I've worked with businesses up and down, and you get a claim and they just write a check for the deductible because they know the defense costs are going to be more than the deductible. And then we go through the defense component. And when you look at the defense costs, they are often 3, 4, 5 times what the ultimate settlement is in any of those cases, right? And so,
yes.
So you could even call errors and omissions insurance or professional liability insurance defense cost coverage insurance, because that's ultimately what it becomes.
It is. And one of the reasons why that is true is because, once again, anybody can sue for anything.
Right.
Statistically speaking, I mean, just from Florida bar statistics, while there might be 10,000 complaints against lawyers, you look at the number of attorneys who are actually disciplined, and their name gets published in the Florida Law Bar Journal or the Florida Bar Law Journal. There's a huge difference between the number of claims that are brought against attorneys for misconduct versus how many are actually disciplined. Well, what happened to the other 9,700 claims? Well, nothing happened, but you might have had to defend yourself. There was no damage award. You weren't disciplined by the court, but you spent $10,000 hiring an attorney and experts to defend you from your client who claims that you charged them too much after you withdrew from representation. And that happens if you make a decision that you don't want to represent someone in a particular case anymore and you withdraw, you fire them, or they don't pay you and you sue them for unpaid attorney's fees. There's almost a guarantee that you will have a claim for misconduct.
Always
not viable.
A bad thing to do.
Always a bad thing to do.
Yes.
Yep. Risk management tip. But what I'm saying is that anybody can sue for anything. What's important is whether they're successful or not. And there's a huge disparity between cases brought and cases that are successfully prosecuted and result in a damage award. I mean, there's a lot of tort reform out there to try to help that. And there's a movement, across the United States against SLAPP suits. So we would like to think that those are going down. But I read 4 industry newsletters every day. And there are notes in the Insurance Law Reporter literally every day about enormous and ridiculous cases that are brought against companies, corporations, individuals, law firms that are thrown out of court after years of litigation. And if you don't have coverage for that, it can bankrupt you or your firm.
Right.
Just the attorney's fees and costs. And if you have professional liability insurance coverage, you're not going to have to worry about those things because your fees are covered beyond the deductible. Your costs are covered. Your costs are covered beyond the deductible. If there is a settlement, because you get to the point where the fees are actually exceeding your possible potential liability or any possible damage award that could occur, you may want to your insurance company help you make the decision to resolve your case. So the damages are smaller than your actual fees. That is not unusual. Look at wage and hour claims when the fee is statutorily triple damages. So what I'm saying is, there is a huge percentage of cases where your only fees and costs are your fees and costs.
Right. Well, good. All right. Well, I want to thank you for being on here. But I have a couple of final questions. Okay.
Sure.
So if you had to give 3 pieces of advice to law firm owners about their professional liability insurance policy as they grow, as they decide to, move their firm on, retire, that type of thing, what would those components be?
My best advice is protect yourself like you would protect your home, protect your firm. There's nothing better in a high stress vocation than having a little bit of peace of mind. And honestly, professional liability insurance gives you peace of mind. You're not going to be concerning yourself in the middle of the night of catastrophic damage because you got a letter from the Florida bar, or you've got a complaint that came from the process server about something that occurred 2 years ago by a member of your firm. You're just not going to have those concerns. Okay, so peace of mind. Don't set it aside as something that you might not need.
Right.
Think of it as a wellness factor.
Perfect.
Another tip is take a look at your coverage on a yearly basis. Secure coverage that's right for you, because one of the mottos, longstanding watchwords or slogans of Florida Lawyers Mutual, and if anybody who's read a Florida Bar journal or gone to a Florida Bar event, I'm sure you've seen something having to do with Florida Lawyers Mutual, is that even very good lawyers can and do get sued.
Absolutely.
By not, the mistake that I want to warn people against is the myth that, well, I'll never get sued. I'm an adoption attorney. Nobody would sue an adoption attorney. This is happy law. No, I'm not going to get sued. Or I'm a brand new lawyer. I don't have risk. And if you can go and look at statistics as to how many mistakes are made by, I'm not going to call them baby lawyers, but by brand new lawyers. Don't think that you're not going to make a mistake. And I use the adage, this is why we call it the practice of law. Right. There's always something new. There's always going to be a change to the rules of civil procedure that you might not have caught. And you make a mistake. Law changes constantly. That's why there are very few general lawyers out there. So pay attention to your coverage and contact your insurance carrier when you make a substantive change.
Or you get a claim.
Before you get a claim. Because if you don't have your coverage, it's not going to be there literally a day late and a dollar short.
Right.
You don't want to be covered short. And my last tip is pay attention to the changes in the legal environment, especially when it has to do with technology, AI, cyber risk. There's a lot out there that we really don't know that is actually a risk to us, but hasn't made the news yet. Technology is changing so dramatically on a daily basis, and AI, artificial intelligence, is changing by leaps and bounds on a daily basis. Even the people that created AI have not contemplated all of the risks that have resulted in damages to businesses. And one of the biggest vocational targets, unfortunately, is law firms, because we handle confidential communications and we handle money.
Yeah.
So don't think that it cannot happen to you, and make sure that you have coverage. And those are my 3 tips.
Excellent. Thank you very much. How can people get in touch with you if they have any questions?
You can call me. My name is Peggy Hewitt. My email address is Peggy, initial H, Peggy H at flmic.com. We have a great website where you can get a quick quote and not actually have to talk to an underwriter. And I recommend that you just go ahead and give us a call at Florida Lawyers Mutual. We're locally in Central Florida. You will actually talk to a live person because we are a direct write company. And you can actually talk to the underwriter that you will work with for however long you have your last name, because we divide the underwriters up by the alphabet, and you get to know your underwriter. But give me a call, send me an email, go on to our website at flmic.com and take a look at the benefits that we provide, including free CLE. We have more than 35 hours of CLE up on our website. 20 of those hours are in board certification level CLE. So check us out on our website. and see what our benefits are and get a quick quote, or get our number, get it to remind myself. Our telephone number is 800-633-6458, and my direct line is 407-278-0291, and we'll do everything we can to make sure you're covered.
Perfect. Thank you, Peggy. I appreciate it. And I will look forward to talking to you again soon.
Thank you very much, Ed, for inviting me. I can't wait for our next CLE.